Hello everyone, welcome to Court with Krissy. Did you miss me? Sorry, I've been away for a couple of days with Influenza A. No naughty adventures, I promise. But I'm back with 4 quick court clips you probably didn't catch, including the man who put me on the Law Talk with Mike map. Holy wow, he has his 3rd DUI. I hope you like it. Court with Krissy is now in session.
Okay, for some reason I had solid down. All right, thank you. All right, Mr. Inclan, why don't you come up to the podium? All right, this is not. Oh, thank you. This is in the matter of the people of the state of Michigan versus Vincent Matthew Inclan file. This is a district court file, so 24-2619 FY. This is a date and time set for a pretrial conference in this matter. I have Isaac Sneed appearing on behalf of the people. There was a probable cause hearing that was scheduled for January 15th. Mr. Inclan didn't appear for that. He did show up the next day, so I advised him about make sure you appear for court on the days you're required to. So at this point, I believe Mr. Sneed's protocol would be he can either set it for a preliminary exam. Have the people made any offers of a plea?
Your Honor, just one question is the defendant in pro per at this time?
Yes.
Okay. The offer was a reduction from the felony to a domestic violence second offense, which is a 1-year misdemeanor.
So, Mr. Inclan, you are charged with a domestic violence 3rd offense, which is a 5-year felony and carries up to a $5,000 fine. Mr. Sneed, does he have any prior felonies?
No, I don't believe so. There would also be a condition of no jail on that offer, Your Honor.
Oh, okay. So, Mr. Inclan, you understand if you were to be found guilty, you could be facing up to 5 years in prison?
Yes, Your Honor.
Okay, and it would be a felony on your record.
Yes,
you
Your
understand that?
I understand.
So what they're offering is to plead it down to a domestic violence second offense, which carries a maximum penalty of up to 1 year in jail with a Killebrew agreement that there would be no upfront jail. And then you would be placed on probation in district court. And as long as you never violated your probation, you would never go to jail.
I understand how that
Do you
works.
understand that plea offer?
Yes.
Okay. Do you wish to avail yourself of that plea offer?
I'm not going to take the plea offer.
You're not going to take a plea. Are you requesting a preliminary exam?
I am.
Okay, so Mr. Sneed, how long do you'll need for a preliminary exam?
Less than 1 hour, Judge.
All right, Ms. Adams, I'm looking to schedule a preliminary exam date.
If I may.
Not yet. You can't talk about the case to me at this point.
I understand.
Okay. I mean, there's gonna be a prelim. I'll make a decision whether to bind you over on the felony or not. Understand if you hold the prelim, then the plea offer is withdrawn on cases where there's victims, according to the standard of the prosecutor's office. Do you understand that?
I understand.
Okay.
Judge, we could do Tuesday, February 11th at 9 a.m.
Mr. Sneed, are you available? Is this your case, Mr.? I don't know whose case this is.
Yes, and I am available. Thank you.
All right, Ms. Adams, Mr. Inclan will need a notice of hearing. So, Mr. Inclan, I will set this for a preliminary exam at 9 a.m. Do you understand what a preliminary exam is?
We're going to go through everything that happened that day.
It's not a trial. It's just a prelim. So at that time, police officer will testify about the events that occurred. The victim may or may not. They don't actually need the victim to testify. And then I'll make a determination whether there's enough evidence to bind you over on a felony. Do you understand? Okay, and February 11th.
Yes.
And February 11 at 9 a.m. means 9 a.m. Got it?
Yes. I believe a motion of dismissal has been signed on behalf of the.
I have not signed a motion of dismissal. You may have filed one, but I don't have it.
AKA the victim.
The victim, okay, you need to understand, even if the victim submitted that, the people don't have to dismiss.
Okay.
Do you understand? Okay,
So will the plea be available still at the preliminary exam, or that's open?
up until the preliminary exam.
Okay,
And once we hold the prelim, usually the prosecutor's office, if there's a victim, I've seen them, they withdraw the plea. Okay, so
they,
I can't advise you of the law. That's what an attorney's for, and you have the right to hire one or get one appointed. So if you want to reach out to the prosecutor, you can do that, but I can't give you advice. All right? Thank you.
thank you.
You too.
Third, which is a 5-year max, and controlled substance possession of analogs, a 2-year max. On that particular case, the allegations are first that you violated what's called a technical term of your probation by using or possessing any controlled substances. More specifically, the allegation was that on January 22nd, you tested positive for amphetamines and oxycodone. If you're convicted of a technical probation violation, you could be subject to up to 15 days in jail. The other probation term that you're alleged to have violated is called a non-technical probation violation. A non-technical probation violation subjects you up to the maximum for what you're on probation for. So in this case, 5 years for the OUI third and 2 years for the possession of analogs. The non-technical probation violation alleges that you used alcohol on January 22nd, 2025, and that you tested positive for consuming alcohol. So do you understand those allegations?
Yes, sir.
Those allegations are identical in the other file. The only difference is that in the other file, 23-6623FH, you were on probation only for the operating while intoxicated third. So the maximum you could face for the non-technical violation would be 5 years, and for the technical violation would be 15 days. Do you understand those maximums?
Yes.
Because of those probation violations and their potential penalty, you're entitled to a probation violation hearing. At that hearing, you have a right to be represented by counsel. If you could not afford an attorney, one would be appointed for you. You also have a right to have the burden be always on the agent. Mr. Bruniquel would have to prove by a preponderance of the evidence that you did in fact violate the court's order. Do you understand those rights?
Yes, sir. Yes.
You also, then Mr. Trush, has Ms. Touchstone been screened for indigency?
Yes, Your Honor. I did conduct a screening with her. She is going to qualify.
All right, so the court will accept that. You're going to be appointed an attorney, Ms. Touchstone. I'm going to set this matter for a contested hearing, but first I'm going to hear from Mr. Bruniquel and then from Mr. Trush regarding whether and if I should set a cash bond or any other type of bond in between now and the ultimate date of the hearing in this case. Mr. Bruniquel, do you have information that might benefit the court in that regard?
Your Honor, she has failed to meet with her treatment counselor since November, and on top of the consumption of controlled substances and alcohol, the department would recommend a moderate cash surety bond.
All right, thank you. Mr. Trush?
Your Honor, I would ask the court to take a couple things into account when setting the bond. First of which is, I think, with the type of violation allegation that we're dealing with, I think there are conditions the court could put in place that would mitigate the risks, such as the court could have her testing daily, could have her on a alcohol tether, those types of things, which would mitigate this. I'd also indicate to the court, Ms. Touchstone has reported to me she has some health issues. Specifically, she has an appointment with a cancer doctor tomorrow at 10 a.m. I would ask the court to consider that when setting the bond. She's reported to me that she does have some amount of available funds for posting a bond. But if it's in an amount that's above what she's able to post, I would suggest to the court or ask the court to consider a furlough for her to make that appointment tomorrow.
Ms. Touchstone, I've got a lot of concerns regarding the allegations in this case. I frankly also got concerns about your appearance today. I'm not making findings about your appearance, but I see individuals in front of me with severe drug and alcohol addiction issues, particularly those involving methamphetamine, and I'm cognizant of the fact that methamphetamine is not alleged to have been used in this case by you. But when I say I've got concerns about your appearance, it's because you have open sores all over your face. I recognize that that might have something to do with what your attorney touched on, is that you have potential medical issues. And so I'm not making findings there, But it gives me extreme concern when I have allegations that somebody's on felony probation for 2 different DUI thirds and a possession of analogs, having been alleged to drink alcohol and use 2 different controlled substances. Those things alone outside of your appearance give me concern. And I would also know the concern is also caught up. The concern also, and I hear you, Ms. Touchstone, saying that you've got skin cancer. And again, my concern is not mostly with how you appear. It is a concern of mine. But again, I recognize there may be other reasons why you appear the way you do. The other concern that I have, though, is also brought up in the way that the legislature determines to separate these cases, separate them in terms of a technical probation violation, one which is punishable by only a modicum or a little bit of time, and a non-technical probation violation. In the state of Michigan, when you're on probation for felony drunk driving and you are in 2 different cases, the consumption of alcohol is deemed to be a non-technical violation because of the unique danger alcohol poses to you, and more specifically, if you're using alcohol, the danger that you pose to us as members of the community. And that increased risk is something that gives me the biggest issue. I do agree with your attorney in some regards that some of the concerns can be mitigated by having you test, but I would also note that those concerns didn't result in a lack of you using alcohol. They just resulted in the court being able to be aware that you were using. It didn't prevent the risk, it just allowed us to be aware that you were using alcohol. For all of those reasons, I think it's appropriate to set a small cash bond in each of these cases. Bond will be set, it will be a $5,000 cash or surety bond in each of these cases. I'll get those bonds to you. That means you can either post the cash amount or you can contact a surety on each of these cases. I will then immediately set these matters for a contested hearing at my next available date. To the extent, Mr. Trush, you have specific documentation or the attorney representing Ms. Touchstone has specific documentation regarding a medical appointment, I would consider furlough if she's not otherwise posted bond. But consider is the key word. I don't know what I will grant it because I don't know what the need for the appointment is. I don't know what the specific timetable and how difficult, for example, it is to get into those meetings, those doctor visits. I don't know anything about it. So if I've presented additional information, I will consider it. I would always consider it if it's presented through the prosecutor's office, and the prosecutor's office didn't have concerns once they were presented the information. You could present it as a stipulated order, or you could present it as a request through an ex parte motion if you thought it would meet the terms of an ex parte need. So I'll consider it, but I'm not going to rule upon that today because I don't have the information sufficient to convince me of a need for furlough right now. So I'll issue those bonds, Ms. Touchstone, and get them to you. Do you think you'll be able to meet those bonds and be released?
Yes, sir. How much would that be in cash?
It would be $5,000 cash if you paid cash on each case. It would be a suretor's amount, whatever you would pay to a suretor if you chose to use a suretor. But the bond amount I'm setting is $5,000 cash or surety on each case. I'm specifically going to require, it should be obvious, but I'll state it in any event, you remain on probation. You are subject to whatever terms and conditions your probation agent orders, including the need and the requirement to report whenever he requires, and to take whatever tests, alcohol, drug, or otherwise that he orders as soon as he orders them. Do you have any additional questions, Ms. Touchstone?
No, sir.
Mr. Trush, any questions or clarifications?
No, thank you, Your Honor.
Mr. Bruniquel, anything further from the probation?
No, Your Honor.
Okay, thank you, everyone. We'll get this matter set as soon as we can.
All right. Yes, ma'am. What is your name?
Jennifer Norfleet. Norfleet.
Norfleet?
Yes.
All right. This is case number 220445101. Houston, Michigan versus Janiqua Norfleet. Appearances, please.
Lisa Coyle appearing on behalf of the people.
And Lorena Bijan on behalf of Ms. Norfleet, who understands her rights, stands muted and waives the former reading.
Court will continue not guilty plea on behalf of Ms. Norfleet. Ms. Bijan, why should I not continue the $1,000 10% CAPES bond set by Judge Bryant September 24th of last year?
Yes, sir. We would ask for personal bond. My client indicated that she did call the 36th district She received information that she only had a traffic case ongoing, so she didn't know that she still had an ongoing case. That was her understanding, Your Honor, but she knows that she wants to get this matter resolved, wants to show up. Your Honor, we would ask for another opportunity. We do have updated contact information for Ms. Norfleet. She's a lifelong resident of Michigan. She did not make up any excuses, and she knows she's supposed to come to court. So for the reasons listed, Your Honor, I would ask for personal bond and give Ms. Norfleet an opportunity to show up. This is a misdemeanor.
Mrs. Cole, response?
Your Honor, she was given a $5,000 personal bond in July of 24. She didn't show up by September of 24. And then a failure to appear. She had 2 failures to appear before the KPS was issued, Your Honor. This is with her allegedly assaulting a CPS worker, doing a well check. So I don't see how she thinks that the matter went away within less than 2 months if she never came back to court after her arraignment. So, Your Honor, I'm asking for that 1,010% bond to remain in place.
And Your Honor, if I may just respond.
Sure.
Your Honor, I'm not aware of any incidences with the complaining since. It is an old case. I'm not aware of any pending cases. She's not on probation, not on parole, no priors. So given that this is an old case, there hasn't been any contacts, and that Ms. Norfleet understands that she's supposed to come to court, I would ask the court to take that under consideration.
Is she working?
She is. She's in the entertainment industry, Your Honor. As a comedian.
Humor. She's what?
She's a comedian. She works in the entertainment industry.
Riddle me this. All right. I'm going to give you the benefit of the doubt and give you a personal bond. And let me just say this on a personal note, Ms. Norfleet, I think being a comedian is probably one of the toughest professions you can make a living at. Because people pay good money to say, make me laugh. And that is very, very difficult. So I applaud you. Now, Ms. Norfleet, now, I don't want to have the last laugh if you don't show up for court. The joke will be on you then.
I did call, and
okay, ma'am, I just want you to listen. I just want you to listen. Your next court date will be February 5th. If you don't show up, a judge will have the last laugh on you. Is that clear?
Yes, sir.
What's your next court date?
February 5th.
In front of Judge Bryant.
Yes, sir.
Okay. All right, step aside, ma'am. $1,000 personal bond.
Would you please identify yourself?
Me, I'm Paul Kingma.
Are you able to start your video?
Let me see if I can do that. Not too sure how to work these. Okay. Is that better?
Yes, sir. Good morning, Mr. Kingma. We are on the record in case number 25-3512 FD. You're appearing for arraignment purposes this morning. You're appearing with Mr. Hubble, the defense attorney available through the Indigent Defense Council here to assist you. Mr. Hubble, did you have opportunity?
Ma'am, I hired Jim.
Is he going to be here with you this morning?
Yes, he said he was.
I will give him a few moments then to make his appearance. You have appeared a little bit early, so I'll put you back in the waiting room until I see that Mr. Hunt has also appeared, okay?
That's fine. Thank you very much.
Unmute and turn your video on again, please.
Okay, there we go.
Thank you.
welcome.
Gentlemen, we're on the record in case number 25-3512FD. Mr. Kingma, you're appearing for arraignment purposes this morning. You're appearing with your attorney, Mr. Hunt. Mr. Hunt, did you have opportunity to review allegations on the complaint nature of the offense and possible maximum penalties with Mr. Kingma?
Yes, I have, and I believe he understands the charges and the potential penalties. We would waive the reading of the complaint, and I would also indicate I've gone over his rights, and I believe he understands his rights as well.
And how will your client be proceeding this morning?
Well, Your Honor, this is a 5-year felony, a DUI third, as I understand it. I'm assuming that we'll have a probable cause conference set.
Thank you.
And prelim.
Yes. So, Mr. Kingman, I'm going to remind you that you have the right to remain silent. Anything that you say orally or in writing can be used against you. You have the right to have an attorney present during any questioning. If you could not afford an attorney, the court would appoint one at public expense. You have the right to have the attorney present during all subsequent court proceedings. You have the right to a preliminary examination. In this case, the preliminary examination will be scheduled for February 18th. It would be at 11 a.m. with Judge Stepka. Also, on February 11th, you would have a probable cause conference. Mr. Hunt, is there information that you'd like me to know regarding bond conditions?
Your Honor, I really have not had an extensive conversation with Mr. Kingma. I know he has the 3 drunk driving cases. Well, this would be his third, as I understand it. And I'm assuming I believe he's set up on testing at this point as well.
No, sir. He was released on an interim bond. So there has been no testing. So, Mr. Kingma, I'm going to continue the interim bond that you posted. I'm going to place additional conditions on the interim bond. The additional conditions would be that you may not use nor possess any alcohol, any illegal substance, or any controlled substance, including marijuana, any mind or mood altering substances, or any non-prescribed medication. You'll provide a list of your current prescriptions to the district court clerk. You will submit to twice daily PBTs proving you're not drinking. You will also have an immediate urine screen and twice per month urine screens thereafter. You may not enter a bar, casino, or any place that serves alcohol by the glass. You'll have no threatening, intimidating, harassing, or violent behavior towards any person. You'll be respectful of all court employees and care providers during the course of your case. You may not operate a motor vehicle without a valid driver's license, registration, and insurance, nor with the presence of any alcohol, any illegal substance, or any controlled substance, even that which might be prescribed to you. Mr. Kingman, I need to get some information from you, please. What is your phone number and your mailing address, please? And I have your email address so the court can email you a copy of the referral form regarding the testing requirements. The testing requirements begin immediately. I'm going to give you a phone number for Community Corrections Pretrial Services so that you can make contact with them to see if you can get an in-home device.
Okay.
That phone number is 231.
Okay.
The testing requirements begin immediately, so you'll need to work on getting an in-home device as soon as possible. Otherwise, you'll do your twice daily PBTs at New Directions. You will need to have the immediate urine screen this evening, and the urine screens will be at New Directions. Again, the referral form that you'll get via email will explain all of that to you. Mr. Hunt, do you have any questions?
No, Your Honor. I would indicate for the record that since my client is out on bond, we would waive the 21-day rule. He understands he has a right to have the prelim within 21 days. But we've discussed, we're going to have to discuss the case. I'm not sure there's going to be a delay. We'll keep it on the 18th, but I just wanted to make that a note for the record.
And ma'am, I do have a medical marijuana card.
So you can provide that as one of your prescriptions to the district court?
Yes, ma'am.
And you'll need to do that immediately. Thank you.
Yep, I'll go get both of them. My medication list today.
So regarding the probable cause conference and the preliminary examination, Mr. Hunt explained, Mr. Kingma, that you have the right to a preliminary examination within a certain time frame. We call it a 21-day rule. If Mr. Hunt needs more time to prepare to properly represent you at that preliminary examination, he's asked that you will waive that 21-day rule. For right now, it's going to be kept as currently scheduled, but it's possible that Mr. Hunt may need to request an adjournment. So are you willing to agree to that?
Yes, ma'am.
All right. Mr. Hunt, is there anything further?
I don't believe so, Your Honor.
I very much appreciate your appearance this morning, gentlemen. Thank you. And if you have nothing further, you are free to leave the meeting.
Thank you, Your Honor. Please give me a call, Paul.
Will do.